All right, thank you. And I'll let our other panelists get, we have everyone here. So we know time is short, so I'll be quick with the introductions. As I mentioned this morning, I'm Tony Casey from the University of Chicago. We have David Chu from DHC Capital. We have Elizabeth McComb from Paul Weiss. We have Wataru Tanaka. There we go. Professor at the Institute of Social Science at the University of Tokyo. So that's our online, our virtual panelists. And then here we have Deepak Rao, the general manager at the Insolvency Bankruptcy Board of India, and Nubanshu Mukherjee, who's the founder of the VD Center for Legal Policy. And we're talking in this panel about valuation of assets and treatment of claims and contracts in insolvency proceedings. So I think this morning we were kind of thinking about the big picture idea of, what kind of system do you have? How do we initiate bankruptcy? Who's in charge? This panel is now getting a little more in the weeds to say, okay, whatever system you have, one of the main things that has to be done in any insolvency procedure is to figure out what the debtor's assets are and how we treat the claims and contracts that the debtor has entered into before filing. And so one of the big issues in the contracts is what do you do with executory contracts, and how do you deal with ipso facto clauses that trigger in bankruptcy. So this panel is kind of a combination of two topics. We start with the valuations of assets, and then we'll talk about those contract questions. So with the valuation of assets, obviously what I was saying was that you can't run an insolvency proceeding without knowing, or you can't resolve it without knowing what the assets are, what it is you're dividing. You think of bankruptcy as dividing up the pie and saying, what are we going to do with this going forward, and who has ownership? Well, you have to know what this is and what it is worth, and how to figure that out is fairly complicated. And so I guess I'm going to start with Elizabeth McComb and ask her to talk to us a little bit at the high level about the importance of valuation procedures and why they are so important to functioning insolvency systems, and what the key aspects we look for in those systems will be. So if Elizabeth can take us there.
Sure, thank you, Tony. Hope everybody can hear me okay. As you were saying, stakeholder entitlements in any insolvency regime necessarily depend on company valuation. So, definitely certainty in how that valuation is arrived at is really crucial. Valuation is important for a number of reasons and a number of purposes, as you alluded to. Firstly, in determining where the value of the debtor or its asset breaks in the debtor's capital structure, and so who are the fulcrum stakeholders, and who's entitled to the debtor's residual value. Whether secured creditors are over or undersecured, and to the extent they are undersecured, the amount of their unsecured deficiency claim. When you get to the part of an insolvency process where and this is particular to the US, where the restructuring plan leaves stakeholders no worse off than they would be in a liquidation, what we refer to in the US as a best interest tests. And whether a debtor and the value of a debtor and whether a debtor is insolvent, can be relevant for a number of other reasons to an insolvency process, including to assess whether historical transactions can be unwound under transaction avoidance statutes. So that's important too.
And I know thinking about how courts or systems deal with this, you've handled cases in various jurisdictions and had cross-border cases. What have you seen are the kind of approaches that can be taken, and when have they effective and less effective, and what drives a good valuation system, if you will, and a bad one, or what characterizes those?
Sure, sure. So from my perspective, the ideal and most robust valuation metric is generally a market test. And that's because, since market tests are neutral, objective, they're relatively easy to interpret, especially for lawyers, and they provide dissenting parties with a clear remedy to the extent that they believe an existing bid is too low. They can put their money where their mouth is by submitting a competing bid, including, if you're a secured creditor, a credit bid, if applicable. That said, there are situations where a market test may not be appropriate or reliable. For instance, if the debtor's business is rapidly depreciating in value, such that any delay associated with conducting a robust market test would leave stakeholders substantially worse off. The debtor's business may involve certain trade secrets or other confidential proprietary information, which would substantially decrease in value if it was revealed to a wide range of potential bidders. That's always a concern where there are strategics who are eyeing a distressed company. Where the valuation issue is a hypothetical liquidation value, or the debtor's insolvency as of the closing of a historical transaction. It's really hard to go back in time and sort of piece that together. And finally, even where a market test has been conducted, parties may contend that such as temporarily inefficient to allow parties to submit valuation arguments relying on non-market approaches.
You broke up a little there. We may have lost Elizabeth, or do we know if we'd made it so far without a technical glitch. So, Elizabeth, are you still there?
Oh, yeah, I'm back. Can you hear me? I apologize.
Yeah. We can hear you now. Yeah.
Okay. So I don't know where I cut off, but what I was saying is that I think it's important to allow parties to submit valuation arguments that rely on non-market approaches, and in the US that would be commonly done by submitting expert testimony that someone's conducted a valuation analysis using broadly accepted methodologies as DCF analysis, comparable companies transaction analysis, which often utilizes price earnings ratios or similar metrics, and asset-based analysis. I think it's worth emphasizing that while I believe it's important for parties to be able to make arguments based off these methodologies, in my experience, to the extent the market test has been conducted, the result of the market test will generally carry the most weight. And where market tests are become especially important are where evaluation is needed in connection with deciding whether to approve a transaction with an insider.
Thanks. That's useful to think about the kind of market test versus expert approach, and how you kind of, one question we have to think about is how, when you decide to go require one versus the other. And of course, when you use the expert approach in the analysis, you have someone, I'll go to David now, you have a financial analyst, an expert who will give you a valuation. And I think David was going to show us kind of the basics of how someone thinks about valuation when they're submitting one of those reports. So David, maybe you can give us insight on that.
Yeah, great, thank you. I have some slides prepared. Would you better bring them up and then go to slide 3?
Great.
Okay, then to slide 3, if you could. So there are 4 primary valuation methods that we would use as a financial advisor to determine value, and they're generally DCF, relative valuation, asset-based valuation, and then liquidation value. So I won't go into a lot of detail into each, but just share with you some key points. There's also a piece that Judge Sanchi has written that is in the pre-read material, which I think is also a very useful read as well for those that want more information. But in essence, a DCF, it's discounting the free cash flows over the forecast period and the terminal value at a weighted average cost of capital to determine the enterprise value. And then there is a number of ways which you can use to calculate the terminal value, being a relative value approach or perpetuity approach. But in essence, what this method is trying to work out is you generate a forecast, future cash flows, you then discount those to work out the time value of money, which then determines the intrinsic value of the business, which is a theoretically correct approach in terms of calculation. But there is obviously a lot of reliance on assumptions, which then leads to a lot of subjectivity in the valuation. The relative valuation is when you're, like Elizabeth had mentioned, where you're deriving the value based on comparable companies or comparable transactions, and you'll commonly use multiples, which are, for example, EV/EBITDA, EV/EBIT, or maybe a price earnings multiple. But there it is also important to distinguish between what is a enterprise value or what is an equity value, and the difference being depending on what multiple you use. Some of them have taken out the effects of interest and other things that are not for the company, but for certain for the equity holders only. And also the main challenge there is around identifying the right pool of comparable companies that have the similar characteristics to the company you're trying to value. Then you have, as a third one, the asset-based valuation, which assumes that the company is a going concern. Just go back to that slide if you could. Has the slide dropped out or is it still there? I can't see from my side.
It dropped out. I think they're going to pull it back up.
Okay. Yeah, so the asset-based valuation assumes the company is a going concern, and it basically is just adjusting the valuation for market value of assets and liabilities. So if you have, for example, something like a property, you make an independent third-party valuation. If you have something like shares that are listed on a stock exchange, you may then mark to market those shares to work out what is the asset-based valuation. Then you have the final piece, which is the liquidation value, which assumes the assets are sold on a piecemeal basis. And on that basis, typically the advisor will apply a recovery percentage against each of the line items on the balance sheet to then work out what is the recoverable value. And then we use that in conjunction with what we refer to as an EPM or an entity priority model, sometimes referred to as a liquidation analysis model, to determine the percentage return to creditors. And this then acts as the comparator against the restructuring. So that's when you hear, for example, someone like, okay, in a liquidation analysis, creditors will receive 5 cents in the dollar versus under the scheme, they'll receive 20 cents in the dollar. So when they're comparing the 5, they're comparing against this value. So in practice, we will use all the valuation approaches and use them as a cross-check, because valuation is an art, not a science, and we have to look at the different approaches to come up with a range of values as to what might be appropriate. I'll then move to the next slide. If you could just turn over to one slide. Okay, so here I want to illustrate how we use the valuations in a debt restructuring concept. So these were concepts that Elizabeth had also mentioned: value break and allocating the surplus. So what I'll do is I'll just walk you through the chart, which is just a simplified illustration. So what we have is the capital structure, just a simple capital structure: senior debt at the bottom, bonds in the middle, and equity at the top. So just 3 main stakeholders. Then you do your valuation, whether it's DCF or asset-based or comparables, and we work out what the enterprise value is. And in this example, you see that the value breaks in the bonds. So the enterprise value is covered the seniors in full, but is breaking in the bonds. And in that case, equity is then out of the money. So naturally, you will get some valuation disputes among stakeholders because, for example, if you're the equity, you may try to argue that the value is higher so that you're now in the money. Likewise, the senior who have incentive to lower the value may say the value is in the senior, so it breaks in the senior, breaks lower, so that they're fully covered, and then the bonds become the creditor that is being squeezed out. So this is what we look at to see which creditors are going to be the key stakeholders we need to discuss in the restructuring, and it's sometimes referred to as the fulcrum security, as to where the value breaks. And then the second aspect in that is how we allocate the surplus. So we have the liquidation value on the far right, and then you have the value break at where the enterprise value is. So that is the additional amount is called the restructuring surplus, and that is in effect what the benefit of the restructuring is, and then how that is allocated amongst different stakeholders in the restructuring, and who is to be the recipient of that value. And that can obviously depend on how hard each party then tries to justify their valuation to then determine that the value break is either higher or lower, as I mentioned. If we go to the next slide. And then in two other ways that we use it is in distressed M&A. So sale of the company as a going concern, or potentially sale of the non-core assets to raise cash. And in that sense, we're using the valuations to determine what is the price, what is the theoretical price of the business, or what is the theoretical value of the business. But as Elizabeth mentioned as well, this can be supplemented with a market testing process, which may then come out to be higher or lower than the theoretical valuation. One of the challenges with the market test is that in certain markets, there may be no bidders, like something like a COVID type situation where everyone is frozen and there's no real bids because there's just too much uncertainty as to what's happening. So that is one of the reasons that evaluation is used. And then also at the same time for equity investors or white knight investors who want to come in to recapitalize the company, they're also using the valuation to then determine what is the value minus the sustainable debt that's on the balance sheet, to determine what is the value for the equity, to determine how much they should inject in and how much equity they should then take. So that is when you see things like in the news, when the restructuring gets done, you say, okay, distressed debt investor invested $100 million US and ended up with 39% of the company or 55% of the company. They've worked that out based on what they think is the EV minus the debt levels that are going to be carried on the balance sheet, and then the value of the equity that is residual and how much they want to inject in for that. So with that, I'll stop, and then you can take it over from there.
So this is a follow-up to Elizabeth then. So we see these various methods, there's the market test, and then there's the various methods we just saw on the slides. And obviously this comes up in a dispute. And so if a judge is deciding, they've got to figure out which method to apply. They've got to figure out what the value is when they're hearing from experts who are likely saying, oh, this is the right way to do it. No, this is the right way to do it. And so from a kind of thinking about dissolving an insolvency system, is there any principle we can have to guide of should we use one methodology? Should we use another? What's the key that we need to make the system kind of most efficient and best for the debtor in deciding what system to use?
I think two key points. One, I think, is it's in any any legal system really is transparency. I think everyone should have access to the same information, the value valuations, etc., and be able to test that through in a court process with cross-examination, etc. I think what's also important is to the extent possible, there needs to have been run a fulsome process, and that can vary, from situation to situation. Each company is sort of different. Some companies may only need a few weeks. Some really to run a proper process may need months. and I think there has to be an arbiter of value, obviously, and the judge is it. And I know that Judge Sonchi is there with you, and he's an expert on judicial valuation. I think it really does come down to the battle of the experts, and then who the judge thinks is the most credible under the circumstances of the.
Great, thanks. So now I guess a question to Debanshu. India, as we've heard earlier today, has kind of adopted a new bankruptcy law in 2016. And so I was curious to hear, in kind of writing that law, how much thought was given to this problem, and what was it on the drafters' minds? Did it get addressed in the bankruptcy code, or is it, how did that play into the code being written?
At the outset, Tony and all the other organizers, thank you so much for this opportunity. No, so at the time when our law was being designed, unfortunately, we didn't have a market for distressed assets. So there was nothing really to look at. But on the other hand, we had a relatively robust market for M&A in India. And in fact, on the Bankruptcy Law Reform Committee, there were some lawyers who had a lot of background in M&A. And I think that informed a lot of the drafting exercise. And like in M&A, the valuation piece is largely left to the stakeholders. And even in schemes of arrangement, the court only kind of has a supervisory role where they largely go with what the parties decide. Similarly, under our code as well, when the law was being designed, it was believed that this should largely be left to the market to decide. So as you know, the way the law functions is, once a case is admitted, the management gets displaced. And then there is this open bidding process where anyone can bid, and then a committee of creditor gets appointed, which can then select the highest bid. So as far as valuation is concerned, it's entirely left to the stakeholders, of course, on the basis of the information that is disclosed before the bidding process starts. One major challenge is that because the debtor is no longer in possession and it's an IP who has come in, so the quality of disclosure at times is not that high. So therefore, it creates problems for stakeholders to value an asset properly. However, the law also requires the determination of liquidation value for protecting the interest of non-consenting creditors or creditors who don't get to vote on a plan. And around this, there are lots of formal requirements. So no formal requirements for the main deal, for the actual valuation on the basis of which the plan will be approved, but formal requirements around determination of this liquidation value, which is important for dissenting and non-voting creditors. Initially, when the law came in, this liquidation value used to be disclosed to the bidders, so that they know that this is the number you need to ensure that the dissenting folks get. But in practice, what happened was a lot of plans, the kind of valuations that came were around that liquidation number. So therefore, then the regulator realized that this is a problem. So then they stopped disclosing that number altogether. And subsequently, they added an additional requirement to get a fair valuation conducted in addition to the liquidation value. So neither the liquidation value nor the fair value, which is essentially the going concern value, are disclosed to the bidders, but they serve as an important reference point for the committee of creditors, because once the bids come in, then they have a band to look at, and which is basically, and this valuation is determined by independent valuers who are regulated by the gentleman sitting next to us. And so this becomes an internal reference point. And I understand that in most resolutions, you have a number which is between the liquidation value and the fair market value. So yeah, so no formal requirement. The formal requirement was only intended for a limited purpose. But in practice, what has happened is it's kind of become an important part of the process, where kind of committee of creditors relies on this independent valuation exercise to actually take a call on what bid they should go with. One additional complication in the Indian context is that our credit industry is led by public sector banks, which are largely owned by the government. And I have to be objective and say that the sophistication of some public sector banks is lesser in comparison to other public sector banks. So therefore, especially for them, this valuation exercise is absolutely crucial. As far as private banks and foreign banks are concerned, their internal valuation processes are quite robust, and therefore uh, uh, this piece may not be as relevant for them, but especially for public sector banks, it's absolutely relevant. But the role of court is very limited, like because our experience with the bankruptcy law uh, before the IBC came in was very bad because it was a court-driven, administrative system-driven process, and that failed miserably. And therefore, here the law kind of does not give any flexibility to the court to have a say in valuation. So you have to go by what the committee of creditors decides. So, but unfortunately, in one or two cases, the courts have kind of stepped in. Mr. Deepak may want to talk about that, but broadly, that's the regime on valuation, and they're largely market-driven and not process-driven, so to speak.
Thanks. And so I guess lead into the Deepak. So can you tell us a little bit more about like how it played out on the ground, and then also lessons learned if you were having seen the way valuations played out in India, anything you take from that if you were designing a system today?
Thank you, Tony, and thank you, Debanshu. I would be speaking from the administrators or the regulators' point of view. See, as he said that IBC Insolvency and Bankruptcy Code is relatively a new law which came into existence in 2017. With the law came two new professions. Both of them were regulated professions. The first was IP and second was valuers. So IP, that profession, as the chairman spoke before the pre-lunch session, how to control the IPs and all. So that profession came with regulator itself. But the other profession that was of valuers, which was there for 2,500 years. The first book of administrative economics in India, Arthashastra, speaks about the valuers, because at that time valuers used to measure the rent of the land basis on its fertility. Now, from the administrator's point of view or the regulator's point of view, you are going to regulate a profession which has been there for 2,500 years. So the profession is developed based on certain conventions. So it's not that easy to regulate such a profession, number one. Number two, you said the new rule, new law. What has been new here? So the best and the most important thing is, earlier also valuers were there. They were working for banks, they were working for income tax department, they were working for wealth tax, they were working for mergers and acquisitions, but they have not been regulated. After the emergence of IBC, the profession is a regulated profession. Now we take into account everything, whether they are qualified or not, they are prescribed qualification, whether they do have enough experience or not. And third and most important thing is we conduct an examination also for registration of valuers. You can get registered as a valuer only when you pass an examination. And last but not least, the regulator's job is not just to test and control. We have to make sure that they are building up their capacity to understand the changing dynamics of the market also. Market is not stagnant, and valuation as a profession is related to market. So when the market or market's dimensions are changing, you have to keep yourself updated. That's why capacity building is something which we are focusing on. Now, coming to the experience part, what I would say is that IBC is relatively a new law. The jurisprudence is still developing, still evolving. And valuation under IBC, I would focus on valuation under IBC only. So it's a part of IBC valuation. The jurisprudence on valuation is also yet to be fully evolved. So when you're talking about certain cases or certain judicial pronouncements, myself and my colleague who's sitting there, I mean, last to last month, we were shocked or surprised because there was one particular case in India where the adjudicating authority was not satisfied with the valuation, because when the case was, I mean, the matter was under insolvency resolution, a valuer did some valuation and then they could not resolve it. It went into the liquidation and again he had to do the valuation. So there was a lot of difference between the initial valuation and subsequent valuation. And then the property was basically a land and building property. the court took it very seriously. It said ki the value of land and building cannot be decreased to that extent. It was brought down by around 60 to 70% in the second valuation. Said it's practically impossible. Generally, the regulator doesn't have any role to play in the valuation part. It's basically between the valuers and the insolvency professionals, the IP or administrator. But in this context, the court ordered the regulator to go into the valuation. When we got into the valuation reports, when we saw the valuation report, we realized that there was nothing wrong with the valuation, because for a land and building, basically the property was a shop. When you buy or sell a shop in the marketplace, especially when you buy a shop in the marketplace, the biggest criteria is the location of the shop or the visibility of the shop. But in this case, the shop was not located in the marketplace. It was located in a shopping mall. And for shopping mall, it's not the visibility, it's the footfall in the shopping mall which matters how important the shop is going to be. So when the resolution process was on, the mall was running. Later on, when he did the liquidation value, that mall was, the popularity of the shopping mall was declining, and more than 80% of the shops in that mall were closed, and mall was also on the verge of closure. So the liquidation value drastically came down. It was quite practical. So one learning from my side as a regulator or as an administrator is that I think we are focusing too much on numbers. Sometimes numbers do not tell the true story. That is one thing. Number two, in a new regime, everybody needs to learn. Valuation is a core technical job, and it's too technical to be left on judiciary. You can't expect judiciary to define each and everything. So in this perspective, what I would say is that even the resolution professionals need to understand a bit of valuation, because the resolution professional who was dealing with this case, had he explained this case properly to the adjudicating authority, then there would not have been such an order. So everybody needs to learn. And third, what you said, can we learn something from international experience and all? See, it's like prescribing a medicine. Before prescribing a medicine, we need to understand the type of disease we have. In the Indian context, especially under the IBC, what we did, being a regulator, we saw, because as my friend said, there is fair value and liquidation value. So the rule says you have to appoint two valuers. If there is a significant difference between the valuation done by both the valuers, then you have to go for third valuer. Earlier, the definition of significant was not there. Now it was left on an RP, even 10% could be significant and 50% could not be significant. So what we did, in order to understand the valuation, we selected a few cases where third valuer were appointed. Now, of course, we have a definition of that significant. We have 25% as a significant difference, but at that time, there were no such definitions. So we selected around 15 odd cases where third valuer was appointed. And then we saw that 13 out of those 15 cases, the difference between the lowest and the highest value was as high as 100%. 13 out of those 15 cases, the difference between the lowest and the highest value was as high as 13%. And I think Mark Twain said that there are lies, damn lies, and then come statistics. So we didn't just go by the statistics. We went into those valuation reports. And then we realized that most of them use the same valuation standards. In spite of using the same valuation standards, there was stark differences because there were no fixed guidelines. As one of the panelists said, discounted cash flow method. Now the discounted cash flow method is used for a particular unit which is an ongoing unit. Then you have to assume two things. The cash flows in future, which depends upon the market, how the market is going to function, and the rate at which you're going to discount the cash flows. That depends upon the demand and supply of capital and all. So there were a lot of cases where there was no clarity on the assumptions they took for the valuation. So as a regulator or as an administrator, what I would stress upon is these standards, international valuation standards are what we are using in India. They are good, but they are broad standards. And generally, when we discuss international valuation standards, my and my colleagues, we say that it's like a net which is covering the goalpost of a football ground. It can stop a football, but it cannot stop a tennis ball. So in the Indian context, especially in the IBC's context, because the valuation is being done not for a routine property, it's being done for a property which has gone into which has become distress, it has gone into insolvency. So we need to define minute guidelines also, because these broad parameters of international valuation standards are too broad, and sometimes they fail to take into account those minute things. And these minute things cause the difference in valuation. That's what, as a regulator, we understood here. But as I've said, that 5 years time is too small a time to draw a solid conclusion. So gradually we are learning. We have now started working on those guidelines also for the IBC's perspective. Especially for valuation under IBC, we are trying to draft certain guidelines, which, because there are issues where there is no clarity. Trade receivables is one particular issue, where if the trade receivables are 2 years old, then now how you're going to value it? If they're 3 years old, how you're going to value it? Then what would be the reputation of your debtor and all? So all these things are important, and there are no guidelines on that. One particular issue which I would like to focus is inventories. We have seen in cases where some manufacturing units were there were inventories lying in the stock of the company, and then they were being reflected in the balance sheet also. But the valuation of those inventories were done by a finance man, a chartered accountant or a cost accountant. In some of those cases, the inventories inter alia included, I mean, there was a paper mill where inventory had this raw paper, finished paper, and then they had a captive coal plant also. They had coal also in the inventories, which was the value of those inventories was reflected in the books and all. But the valuation was done by a person who was basically registered for valuation of securities or financial assets. So all these gray areas are there, which needs to be worked on. And last, when a panelist spoke about the liquidation value. Liquidation value is something which is really tricky, because let me give you an example. Sometimes the liquidation value can be more than the fair value, because fair value is determined for an ongoing concern. I still remember I had a ceiling fan. My grandfather bought it, and my father was very emotionally attached to that fan, so he kept it for 70 odd years. So when I sold that fan in the scrap market, I got the price which was more than the cost of a new fan, because it had enough copper in it, which fetched me around 1300 rupees, and the new fan would have costed me 1200 rupees. So we have to be very careful while working on the liquidation value and all. Of course, it may be an exception, but exceptions are also a part of rule. So these were the views which, I mean, these are the things which I could notice as a regulator, because I'm handling valuation there. These are the points which I wanted to make on valuation front.
Thank you. And now we're going to change gears a little bit. We're going to start talking about valuation was about the assets and what the estate is worth. Now we're talking about claims against the estate and contracts. And first, we'll talk about kind of the order in which claims are paid, and then we'll talk about the idea of like I mentioned earlier, ipso facto contracts. And so to Wataru, I'll turn now. There's this idea in most bankruptcy systems of priority and what the rule is for secured claims and what the rule is for the order in which you pay out claims. And so I was hoping Wataru could kind of introduce the topic and explain to us, one, what we mean by priority, but also like what makes it important to an insolvency system, and what is a well-defined priority system, and why do we need that?
Well, thank you. In general, the priority rule specified by the law outside the bankruptcy should be protected in insolvency proceedings as well. Otherwise, some rights holders who would have their rights protected more preferentially in the insolvency proceedings would have an incentive to use insolvency proceeding in order to receive preferential treatment. Such benefits associated with receiving preferential treatment are merely a transfer of income from the other types of rights holders, and do not represent an increase in the benefits of society as a whole. Because insolvency proceedings are costly mechanism, they should be used only when the benefits to society as a whole can be expected to be enhanced by those proceedings, and they should not be used for the purpose of transferring income. This is a basic idea, and in practice also, most jurisdictions protect the priority relationship. The priority relationship among rights is generally protected. That is, secured claims have priority over unsecured claims, and unsecured claims have priority over shares, equities. On the other hand, it is debatable whether priority among rights should be absolutely protected. If the priority of claims over shares must be absolutely protected, then shareholders would lose all of their interest in the data company when the data company is insolvent. But if that were to happen, the data company controlled by its shareholders might have very little incentive to file insolvency proceedings in the first place. And also, there may be cases, especially in privately held companies, owner managers' contribution could be very important to the realization of the firm value. So in such companies, it may be better to maintain the status of existing shareholders in insolvency proceedings, even when creditors have their claims cut by reorganization plans. I think it is famous that there is an absolute priority rule in American reorganization procedures. There is a Chapter 11 procedures. But I guess it is important to note that absolute priority rule is a rule that is required in cram down cases. By cram down cases, I mean the cases where one or more classes of rights holders are against the organization plan by a majority decision, but court still wants to approve the plan. In this case, absolute priority of claims over shares must be protected. But if each class of impaired whose rights are impaired vote for the plan by a majority decision, then there is no absolute priority rule. All is needed is that each dissenting claim holder must be assured its liquidation value of its claim. So I think the more difficult question is whether we should whether departure from the absolute priority rule may be justified even when one or more class of rights holders oppose the restructuring plan by a majority vote. Such a deviation from absolute priority might be justified, for example, to provide an incentive for the data company to initiate the insolvency proceeding. If so, then a rule might be supported that priority of claims over shares can be relative, not absolute. However, under such a rule that allows shareholders to retain their position when a corporation goes bankrupt and creditors are forced to cut off their claims, there would be a strong important risk of encouraging moral hazard on the part of the data company's shareholders. That is, shareholders might undertake a too risky business at the cost of creditors. So therefore, there is a trade-off as to whether the priority rule should be absolute or relative. And it would not be surprising that the rules differ from jurisdictions to jurisdictions. However, I am not sure if the differences among jurisdictions are reasonable and reflect economic and social conditions in each jurisdiction. Rather, the differences may be based on more political factors. For example, which of the data firms or credit financial institutions have more political influence. Well, should I stop here, or should I proceed to special treatment of some types of claims?
Let me inject. So that last point I think is a useful point to hear the other panelists' views. So maybe I'll start with David, but I want to hear kind of everyone's view of how important you think the having an absolute priority rule is, and how important it is to have or not have exceptions, and kind of, I know there's debates in various jurisdictions between absolute and relative priority and these exceptions, and I'm curious to hear around the panel your views on whether it's okay to have exceptions or whether absolute priority should truly be absolute. So maybe David, you'll start, and then Elizabeth, and we'll hear from the other panelists.
So in restructuring, so when we refer to restructuring, we mean schemes. We have a cross-class cram down because similar to the US model as well. And there you can cram down creditors that are out of the money, provided they're no worse off than a comparator, which is typically liquidation. So that's where valuation comes in. But this only extends to creditors. Equity still votes in Singapore. So if you had a situation where creditors, one class of creditor didn't receive any payment or didn't receive full payment, equity may still be in a position to get something in this case. And usually that comes down to getting the shareholder approvals. The shareholders will use some of that leverage to get something out of it that they probably shouldn't otherwise get, but it's kind of more like a carrot to help vote for the deal and to pass it through successfully. I think where it's important is where you have family-owned companies that are running the company. And most in Asia are family-owned companies. And then giving them some equity that is material, I think, is important because they know the customers, they know the suppliers, they have the know-how of the business. And I think you need to keep them aligned. It's a little bit different, say, for example, where you may have a private equity sponsored company and then you have a professional management team. And I think in that case, it may be easier just to squeeze out the private equity firm and just give them the consent acceptance fee as opposed to giving them anything to align just because of their interest there. I think where you do see it a bit more of a challenge is places like Indonesia and China, where if you're located offshore, that can be a challenge. And you're seeing that in now the PRC real estate sector, where a lot of the Chinese developers are going in through restructuring, and the offshore creditors are trying to form committees. They're trying to get a seat at the table to get a bit of leverage in the restructuring, because they're sitting offshore and the companies, their all assets are all onshore, and that's proving to be a challenge. Is that they're potentially going to have to try and get that seat at the table and try and get some of the value for them, even though they're sitting offshore.
Thanks, Elizabeth. Your views?
Yeah. So what's key, I think, in sort of all these discussions and in sort of fashioning an insolvency system is really certainty. It's sort of knowing where claims sit, and who gets to recover what. And so I think having an absolute priority scheme that is known is super important for an efficient insolvency system. But I do think that domestic priority schemes, and I think Professor Tanaka touched upon this. I think they really to a large extent are further domestic political objectives, such as wealth distribution, protection of less sophisticated stakeholders, rather than insolvency law objectives, which I view as generally more neutral, such as preserving sort of going concern value. I think in terms of which insolvency law should apply, whose priority scheme, I think you touched upon this, Tony, which is whether there should be a unified sort of priority scheme approach across, all countries. But countries, obviously have a more territorialistic approach in terms of, contending that any assets in their country should be distributed pursuant to their own, priority scheme. Or you can think of some countries where pension claims, have to be paid before any creditors get anything, or employee claims, have to be paid, first off the top. So, there's the political sort of objective and agenda at work there.
Thanks. Deepak, your views.
See, the various stakeholders, and every stakeholder has infused one thing or other. Now, the most crucial task is to make a proper balance or balancing the stakeholders' interest. Now, when you talk about the priority, what is better, whether it's absolute priority or any other system, from a regulator's point of view, what I would like to say is, for us, it doesn't matter whether cat is black or white. As long as it catches mice, it's good for us. The reason is very simple, because any law, how good it may be, is not a foolproof law. The time changes, law also needs to undergo some changes. So in Indian perspective, I think it's 53, section 53 is there, which he's a legal expert and we rely a lot on him. So this stage is also not an exception. So there is some vagueness there. So when you go through a law and there are certain provisions in that, you need to understand why those provisions have been incorporated in that code or in law. So any law has to be within the broad framework of your constitutional objectives. If you see the waterfall mechanism in IBC, the workman's due and the dues of the secured creditors have been given the topmost priority. It may sound contradictory that they come from two different corners of the stakeholders, but the dues of secured creditors are given the topmost priority because for a country like India, there is enough scope for expansion of the market, and the credit system, as I said, that among the institutional creditors, still the public sector banks dominate. And most of these banks have rural branches and they don't have that much of exposure, barring a few which have got urban branches and then they are in industrial financing and all. So we need to support institutional creditors in order to expand credit system in the country and to infuse more credit in order to develop a market. So that was one particular reason why we gave topmost priority to institutional secured creditors. The second is the constitution says that the core objective of our constitution is social and economic equality. That's why we have treated the dues of workman for 24 months, for the previous 24 months from the date of the commencement of the liquidation, at par with the claims of secured creditors. Now, here the workman should not be misunderstood with the employees. The workmen are not employees. They are those who are working for they don't have any social security. Unlike the employees who are on the rolls, here the workmen are not on the rolls. So a system, what is good or bad, should be within the broad contours of your core administrative or political objectives, as one of the panelists said. The political objectives of your government or your governance matters a lot. And then there have been certain things. Recently there is a ruling by a Supreme Court, I think it's in Rainbow Papers case, where said that even the government dues should be treated at par with it. But when the law was framed, we kept the government dues below all these claims because we thought that if we promote the credit structure in the government, that would expand the market, that would help the market to expand, and the revenue which would come to the government would otherwise be beneficial to the economy and all. But now the court of law, the apex court, has said that the money which would have otherwise gone to the government would have gone to the contingency fund or that consolidated fund of the government of India, and the money would have been spent for the betterment of the masses. So the government's due should also be treated at par with the due of the secured creditors and the workmen. So there has been some ups and downs in this case. And then the legal interpretation, there was one particular, I think, a case where the Supreme Court itself said that the term equality should not be stressed to an extent that even unequals are treated as equals. So if we are relying too much on the term equality, then it should be clearly defined. It should be clearly spelled. Now, we have different set of creditors, secured creditors, operational creditors, unsecured creditors and all. But even in case of secured creditors, I think there is a need to have a clear-cut definition. If my secured interest is 1% and your secured interest is 99%, we should not be treated at par. So this clarity is something I think which is missing in our code also. But I think the US system has something from which we can learn a lot, because it's not the creditors, it's the claims which matter there. It's the unsecured claims or the secured claims. So there are things which we can learn from there. So there is another case where the insolvency has been resolved, the resolution applicant has bid for the corporate debtor, and then he is prepared to take over. But the creditors are fighting among themselves, keep what they'll get. So now the adjudicating authority has said, you have enough time to fight. You can fight later on also. So when I talk about clarity, I think then there should be clarity on this front also. If the members of the committee of creditors are fighting, how should they fight? And to what extent they fight and how long they fight? Because there should be an absolute clarity here also. So all these things need to be tackled. A good system is a system where there is certain amount of clarity. You can't have absolute clarity, but this should not give scope for interpretation in different manner. And then another thing which I would like to point out is, you are talking about the clarity of the process, that is okay, but the absolute clarity in terms of objective should be there. The core objective for IBC is to make sure that the corporate debtor doesn't go into liquidation. So your rules should not directly or indirectly encourage any stakeholder to pay for liquidation. In the current scenario, there is a scope where a secured creditor, especially when if he's a decent creditor in the committee of creditors, he thinks that his situation would be better off if the matter goes to the liquidation. But that is something which I think in any system it should be avoided, because that defeats the basic purpose of your, for us it's insolvency and bankruptcy code for reorganizing a distressed firm or reviving it. So that is one thing which I wanted to point out.
Yeah, I think Deepak has broadly covered everything, but I just want to add one policy piece. When the law was being designed, India was undergoing a very bad NPL crisis. The size of non-performing assets in our banking sector was really, really high, and therefore the financial creditors, the banks and financial institutions, they were given a very high say in the resolution process, and therefore the law essentially recognize only two kinds of creditors for the purpose of resolution: financial creditors and operational creditors. As far as reorganization is concerned, there was no sub-classification of secured, unsecured. So in that sense, this was a very unique design, at least in the original version of the law. However, uh, uh, and for a plan to be approved, it could go through with the approval of 75% of the financial creditors. No rules on priority whatsoever. So basically, these financial creditors could approve any plan whatsoever, subject to the protection for the operational creditors who didn't get to vote, who had to be and who used to get their liquidation value. But the order of priorities for determining the liquidation value came from the liquidation regime, which is section 53 that Deepak referred to. The reorganization plan had no requirements on priority whatsoever. However, of course, there was a lot of litigation on this, and the committee of creditors, one might say, abused the discretion or the freedom that they got in several cases. There was random assignment of or random kind of identification of creditors for the purpose of payment, like have random cutoffs saying that if your debts are under $100,000, then you'll be paid your entire amount, but if it's higher, then you get nothing. If you are an operational creditor. And the argument was because if we were to if you were to give you liquidation value, everybody will get zero, so might as well get, so you should be happy if you're getting something. But obviously there was a lot of litigation on this issue, and ultimately in one particular case, our appellate tribunal was so unhappy with the kind of distribution in one particular case that they said that the assets have to be equally distributed among all the creditors, including secured creditors. So everyone gets 60%. And then obviously that caused a huge uproar in the market, and secured creditors were like, what is this? This law was drafted for us. This can't be the case. And then subsequently the law was amended in a certain sense to override that ruling. And after that amendment, so now we have a system of absolute priority where now we say that for a plan to be considered fair, it must follow the same order of priorities as in section 53. So essentially, now from no priority, we have moved to a system of absolute priority. And we've seen that this has helped in reduction of litigation, because obviously, as Professor explained, when people know about their order of priorities ex ante, that kind of reduces the risk of litigation. And as Deepak indicated, although the government originally was supposed to come lower down in the order of priorities, and they accepted that at that point, now there is the Supreme Court ruling, which has now questioned all of that, and it's just happened. And they're saying now the government stands at the same pedestal as secured creditors, which I think is a big one. People are talking about it. Yeah, the government itself is challenging that, because interestingly, this was this case related to a state government statutory due, not the central government statutory due. And we have this politics between central and state governments in our country. And so we don't really know what the final outcome is going to be. But I think the government's position is that government should stay down, given the fact that biggest lenders are also public sector banks. It's indirectly the government. So it's in a way government versus government as far as the payment to the tax authorities and other statutory dues are concerned. Yeah, probably that.
Great, thanks. So I know we could talk about priority for kind of 3 panels, but I want to get to the last topic before we run out of time. So the last thought on topic on claims and the way we treat them is executory contracts and ipso facto clauses. So I was hoping, Elizabeth, you could kind of explain what those words I just said mean, and what the issue is, and how we should think about executory contracts.
Sure. So an executory contract at a high level is a contract under which there remain unperformed obligations on both sides. Or where both the debtor and the counterparty have continuing obligations to perform. You talked about ipso facto clauses. So an ipso facto clause is one in a contract that terminates or otherwise modifies a contract based on the insolvency or financial condition of a debtor, or the commencement of an insolvency or similar proceeding involving the debtor. So gives the other party the right to terminate the contract. In the US and certain other jurisdictions, these ipso facto clauses in contracts are generally unenforceable. And, that's because the policy behind it really is twofold. One, it's to prevent creditors from contracting around bankruptcy and the insolvencies law's policy objectives pre-petition, and to prevent creditors from obtaining a preferred position relative to other creditors that are similarly situated. That said, countries that have enacted the ban on ipso facto clauses generally have certain exceptions. So for instance, here in the States, certain types of derivatives, including forward contracts, commodities contracts, and swap agreements, are exempt from a ban on ipso facto clauses. And this really reflects a policy choice, as I alluded to before. Congress determined that the benefits of a smooth functioning market in these types of derivatives outweigh the policies underlying the ban on ipso facto clauses.
Wataru, can you share with us the kind of Japanese approach and your views on whether or not we should ban or allow ipso facto clauses?
Well, okay. Before I discuss ipso facto clauses, I like to talk about a little executory contracts, the default rules of executory contracts. In Japanese law, like American law, in insolvency proceedings, trustees have an option to accept or reject executory contracts. If a trustee accepts the contract, then the counterparty has a claim for performance, and this claim will become a claim for administrative expenses and will be paid prior to other claims. And if the trustee chooses to cancel, reject the contract, then the counterparty has a claim for damages, but the claim for damages will become unsecured claims. Well, I think that this rule is somewhat peculiar. Somewhat strange because in the common law countries, I think there is an idea that this rule for executory contract just reflects the general principle of contract law. That is, the debtor promisor has an option to breach a contract and pay the damages for expectation interest. But in civil law countries like Japan, there is no freedom to breach a contract because the creditor has an option to demand a specific performance of the claim. So it is strange that civil law countries follow common law countries only in the insolvency proceedings. And in the scholarly literature, the rule for executory contract is just sorry. I think in the scholarly debate, there is a notion that freedom to breach a contract is justified by a theory of efficient breach of a contract. That is, if the debtor has an option to breach a contract and pay the damage for expectation interest, then the debtor has an incentive to breach a contract when and only when the performance is inefficient, and the debtor has an incentive to perform when and only when the performance is efficient. But this argument assumes that the debtor, if the debtor breaches the contract, then they can pay the damage for expected interest fully. But in case of insolvency, that if the debtor or debtor's trustee chooses to reject the contract, it is almost certain that debtor's estate cannot afford to pay the damage for expectation interest, as long as the claim for damage will become a general unsecured claim. So in this case, if the debtor cannot pay fully the damage for expectation interest, then giving the trustee an option to accept or reject a contract, then the trustee has an incentive to breach a contract excessively. So I'm not sure why civil countries like Japan follow the common law approach in the insolvency proceedings. It seems we Japan, Germany, as civil countries seem to follow the idea of freedom to breach a contract in the very circumstance where this idea is least attractive. Actually, I heard that at least one jurisdiction, Spain has a rule that when a debtor chooses to reject an executory contract, then the counterparty has a claim for damage as a claim for administrative expenses, not a claim for unsecured, not just as an unsecured claim. I think this rule will not distort incentive to choose whether to accept or to reject executory contracts. So I think this reflects a better policy. As for absolutely ipso facto clauses, there is a Supreme Court decision in Japan that ipso facto clause violates the public policy of insolvency law. So thus is invalid. But as Elizabeth comments, there is a rule of exception for financial contracts. That is a netting contracts, which kind of ipso facto clause will be valid by the statute. Thank you.
David, I'll turn to you.
Sure. So Singapore incorporated the ipso facto provisions in its Insolvency, Restructuring and Dissolution Act legislation, and it's under Section 440. So Section 440 specifically refers to not being able to terminate or amend by reason only that the company is insolvent. And the basis of that is allowing termination of key contracts can predetermine the fate of the company that's in distress, and basically undermine the ability to save the company as a going concern if all your key contracts and key customers or suppliers are terminating their contracts. Now, in practice, I think there are a lot of other reasons that could still allow for termination. So, for example, one of the cases that we had seen was a construction company had a big government contract, and they potentially were looking to terminate it. But if it wasn't, the law wasn't in place at that time, but there were other reasons they could have terminated if they so wished, like the company's performance, because they had lack of working capital, they were way behind schedule, they hadn't done certain things. So I'm sure they could have found other reasons to terminate. The other one is that under the ipso facto provisions in Singapore, it doesn't explicitly prevent a lender from making a claim against the guarantor under a guarantee. So that could still leave the guarantor at some risk, even though the provision is in place, because it only applies to the company itself that is under some form of insolvency procedure as for the protection.
Debanshu.
Yeah, so our experience here is informed by the position of law before the IBC came into force. Under our old law, it was possible for the administrative authority that was in charge of bankruptcy proceedings to override contracts, suspend them, terminate them, do what they liked, which obviously caused a lot of disruption and problems. And therefore, in the new law, one of the provisions was that the plan must ensure that it complies with applicable law, which also includes contract law. So therefore, the underlying principle is that the freedom of contract needs to be upheld, and if someone is signed up to an ipso facto clause in their contract, then that has to be essentially honored. But we also realized at the time of drafting that there might be some services that must be necessary, which if terminated, you'll not be able to resolve the company at all. And therefore, certain basic essential services like electricity, water supply, telecom, IT. So these were categorized as essential services, and these services cannot be terminated as long as the suppliers continue to be paid. Recently, the law was amended to give the insolvency professional additional flexibility to identify certain suppliers and say that, no, this guy is really essential for the insolvency resolution. And once I've determined that, then this guy must necessarily supply. So that flexibility was subsequently added, because obviously there were cases where people stopped supplying and then that affected the proceedings. Uh, in one major case, it was a very interesting Supreme Court ruling, uh, where there was this solar power plant. Um, it was in distress for a very long period of time. It had only one contract which was basically a government contract, a power purchase agreement. And if that agreement had an ipso facto clause, but if that agreement terminated, it was virtually impossible to resolve the bankruptcy, because that was the only customer that company had. So uh, based on the facts and circumstances of that particular case, the Supreme Court said that you cannot terminate, although the law is kind of gives you the flexibility to terminate. In this particular case, the Supreme Court exercised its discretion to say that you can't terminate. But I think my sense is it's a very limited exception. As far as the position of the law is concerned, it's still uphold the freedom of contract. And so there is no so essentially one could terminate on the ground of insolvency if they like. In practice, I understand that in most cases the IPs are able to get the folks whom they really want to continue supplying goods and services to supply, uh, uh, because the old management is no longer in control. The suppliers have confidence in the system. And in most, so this is fortunately not a huge problem in the Indian context. uh, More often than not, people continue to supply even after a company goes in and don't exercise the ipso facto clause. In most cases, it's only in one of those cases like that I mentioned, where the company has been in distress for a very long period of time, past payments haven't come, etc., where people want to get out. Whereas in most of the cases, uh, I think uh, you know uh, you have continuity of services and supply of goods and services.
Deepak, any additional thoughts?
Yeah, what my friend Debanshu has said, in Indian context, it's quite okay. And there was another case, I think ASL Limited. There was a company which was into the business of these mobile networking and all, and then a spectrum was allotted to it. So it went into insolvency, and then the court said, see, if you withdraw the license granted to the company to be in the mobile business, to be in the business of the telecommunication, this wireless network and all, the entire basis of the business is that license itself. So you cannot withdraw it. So there was another case, ASL Limited, where which can be, I mean, he referred to one particular case where which can be called as a benchmark ruling by the apex court, and ASL Limited is another one. There is another point which I wanted to touch is there's always been a conflict between that contractual freedom versus corporate rescue. But what is better, what comes secondary is basically theory of relativity. You might have seen that during this COVID period, a lot of jurisdictions have introduced restrictions on use of ipso facto factors, ipso facto clauses and all, just because for them revival of a corporate was more important at that time, because we needed to revive those corporate, because most of them were failing because of the reasons beyond their control or because of the reasons beyond anybody's control. So there are two things which I wanted to say. First is that when we enter into a contract, we take into account or we anticipate the problems which may arise in future, and then we try to incorporate those problems in an agreement, in the form of an agreement, because if something goes wrong, I can take advantage of that. So that's how market functions. So that's the market's independence. The second is you have to somehow rescue a corporate. You don't want it to just eliminate from the market. So you want to maintain the size of the market. So it's the wishes of the market versus size of the market. So there has to be a very judicial choice, and the choice depends upon the time and the situation. During the COVID period, it was absolutely necessary for all of us to revive and rescue those corporates. So it was but natural for most of these jurisdictions to to use those anti-deprivation laws and all. So what is better depends upon where do you stand.
Great. Well, I see we have 2 minutes left, so I think we have time for one question from the audience if anyone wants to bring a question. So otherwise, we'll take our extra 2 minutes. So, Well, I want to thank the panel. We covered a lot. So thank you all for filling us in on this. And yeah, thank you.